All right, we've got 18 minutes to go before 7 o'clock here on this Monday morning. It's so good to have you with us. On Thursday, Corruption Watch and the Right to Know campaign submitted new evidence to the High Court regarding the Arms Deal Commission. The two civil society organisations filed a supplementary affidavit in the High Court in Pretoria for the court to review and set aside Judge Willie Seriti's 2016 findings. Now, the Seriti Commission found that there was no corruption involved in the deal. But according to new evidence submitted by the two organisations, the Commission not only failed in its investigation, but it also misled the public. Talking to us now, we have David Lewis, who is the Executive Director at Corruption Watch. David, good to see you. Thanks for coming in. And in our Sea Point studio, we are joined by Hennie Van Vuuren. Now, he is the Director of Open Secrets, who refused to give testimony at the Seriti Commission. Hennie, thank you. Good to have you here on Morning Live.
Thank you, Leanne. Good morning.
All right, so I'm going to start with David here in Johannesburg. In your documents that the Commission lied to the public and hid evidence of corruption, what new evidence are you presenting this time?
Well, you know, I have to go back a second. I mean, we filed, the two organisations filed an application, I think some 18 months ago, for a review of the Seriti Commission, and then came the tooth-pulling process of getting the record out of the state. And, you know, in the end, after a lot of toing and froing that I won't bore you with, we've got a fraction of the record. And the record is the basis on which the Commission made or should have made its decision. And trawling through that record, we have drawn out examples of situations where either the Seriti Commission presented in their report a misleading account of the evidence that was submitted to them, or else they didn't further investigate evidence that was submitted to them. So, for example, Bell Helicopter, an American company, said that it had been bribed. The Seriti Commission never looked further into that matter. There was a meeting that is alleged to have taken place between, at the time, then Deputy President Thabo Mbeki, Seth Balate, who was the head of Arms Corps, and four BAE, big British armaments firm. And the Serious Fraud Office in the United Kingdom provided the Scorpions with this evidence. That was passed on to the Commission. And again, they never asked questions of any of those people. And, you know, the point that we're making here, that a commission of inquiry is not like a court process where two contending parties come before the judge, present their evidence, and they make up their mind. An inquiry is an inquiry. This is what the power of a commission of inquiry is. It is meant to inquire further. It can take its inquiry wherever what is presented to it leads it. And it can't not further investigate allegations that are made or information that is supplied to it, if the information suggests malfeasance. So that's what we're doing, and we're very anxious that the court should lay down what the kind of standards are that are required of a commission of inquiry. And of course, we're also intent that nobody should be allowed to claim that they have been vindicated by this finding of the commission, because we believe that the commission could not have arrived at that finding. It could not have arrived at any credible finding on the basis of its lack of inquiry and the manner in which it treated the evidence.
Okay, I'm going to bring Hennie into the conversation now. Hennie, I want to get your views on all of this, and obviously just some response from what David Lewis is saying as well.
Yeah, thanks, Leanne. I mean, I think we firstly need to recognize that it's an incredible job that civil society does in this country, and this is a good example of trying to enforce accountability where the state has failed us. If it wasn't for organizations like the Right to Know campaign and Corruption Watch, I think the call by over 40 civil society organizations that the Commission should in fact shut down its work because it had been so fully compromised in the process, I think the public wouldn't know about the scandal. And I say it's a scandal, Leanne, because I think we need to recognize firstly that this arms deal of the late 1990s, besides the fact that it moved shifted money that should have been used on social spending at the time to buy weapons that the country didn't need. But it was the big political scandal of its time that is the crucial link between the corrupt arms deals of apartheid and some of the elements of state capture that continue in our country today. And I think the argument has been that the cover-up allowed those parties that have been so central to the story of corruption to get away, and thereby, in a sense, allowed corruption to lead and bleed into the issues of state capture that we experience now. And so the evidence suggests, I think, very strongly, which David has just spoken to now, of an attempt by the Commission to willfully mislead the public, to not consider key evidence, to reject efforts by foreign countries who are trying to assist South Africa to take up those offers for assistance, and to protect the powerful, protect President Thabo Mbeki, potentially protect Mr. Jacob Zuma, and of course to protect the big arms companies in Italy, in the United Kingdom, in France and elsewhere. And I think this is really at the heart of the scandal. It's an attempt to protect the powerful at the expense of the public. And I think that sadly the Commission of Inquiry in this instance has a huge amount to answer for the damage it allowed not only to happen in this country, but the damage which it did to the standing of the judiciary by not fully and properly investigating an issue that it was tasked to do.
It's a big worry. I mean, especially when you came out last week, David, with some of the coming through and saying that this is unacceptable, it needs to be investigated further. What your organization was saying, that documents you received revealed that the Commission had hidden evidence of corruption. A, that's very, very worrying, and B, that by failing to access information abroad, it made no attempt to investigate serious allegations of corruption that were put before it, and that the Commission failed to investigate new allegations that have come to light. Yeah. So, all of this puts a very big question mark on the Commission's findings. Yeah. But this new evidence that you have, where did you get it from? Where did you manage to get it?
From the record of the Commission. I mean, this is all gathered from what was in the possession of the Commission. That's the process of conducting a review like this. You're reviewing a decision, and what you ask for, what the reviewing party asks for and is entitled to receive, is the record, the basis upon which the Commission arrived at its finding. And when we got, as I say, a fraction of that record, I mean, I think that the record runs to something like 3 million documents. When we got a fraction of that record and we trawled through that, we identified a number of areas in which, as Hennie has said, foreign intelligence agencies and investigative agencies provided evidence that was not taken into account or not further investigated. And, at times it does appear to have been, either negligent and incompetent to an extraordinary degree, or else willful. South Africans have a sort of quaint confidence in judicial commissions of inquiry, despite us having been all disappointed by them on a number of occasions. And so we're intent that the court should lay down a standard for the conduct of commissions of inquiry, so that we're no longer disappointed by them, or that our expectations of them are realistic. But it is a serious charge. It is a serious matter. We are leveling serious allegations. My understanding is, for example, that no evidence from a foreign policing agency or intelligence agency was incorporated into the Commission's report, despite the fact that all the companies implicated are European companies or foreign companies. You would have thought that they would have been very anxious to cooperate. The Commission would be very anxious to cooperate with those foreign agencies. There's one instance with respect to the Germans, I think, where they submitted an application for mutual legal assistance. It was rejected on the basis that it was incorrectly submitted. It then took them a further 2 years to file another application, and they didn't correct their mistakes at all. So that too was rejected. And then 2 months before the commission finally disbanded, they submitted another application. So they took no evidence from the Germans. The Serious Fraud Office in the United Kingdom investigated aspects of their companies and British companies' involvement in the arms deal. This too wasn't used. In fact, it was used in a manner that was misleading.
Yeah. I mean,
so there's a lot of stuff.
You've spoken quite widely about this. I mean, you also talk about intimate dinners that the then President Thabo Mbeki,
Deputy President,
he was the Deputy President, I beg your pardon, at the time, had with some of the key role players at the time. Again, that wasn't even taken into account. Many instances, which I know are quite open and available, and you've cited them as evidence before them. I want to know, however, Hennie, from your side, why did you refuse to testify at the Seriti Commission?
Yeah, Leanna, I think that the material that's now being produced through this court process, I think, has fully exposed the extent of the cover-up. But I think it was clear, at least to myself and other colleagues who were called as witnesses, and certainly to civil society organizations, that there was a willful attempt to cover up the corruption in the deal and to prevent those who had information from testifying. When we brought information to the Commission of actual corruption, we were told, it was an extraordinary moment by Judge Willie Seriti, that unless we were the authors of that information, so unless we were the witnesses of that corruption, meaning we were either implicated in the corruption ourselves, worked for an arms company or for the government or for one of these corrupt middlemen, we couldn't speak to the material or the evidence at all. And so what that meant was the people who could testify were those who were both implicated or who had benefited or could fear for their lives, because they would have to be whistleblowers who would then testify. And when we compare that to the Zondo Commission of Inquiry that is taking place at the moment, these are simply worlds apart. I think the way that Judge Zondo thus far has handled the work of that commission is a clear indication of a judge who is energetic, who wants to deal with material, and who is open to ensure that there's a safe space created for witnesses. In fact, the very opposite, I think, happened at the Seriti Commission of Inquiry. It was always a kid glove that was put on when the arms companies were asked to produce documents or to testify. Certainly, most of them never testified. They had their agents in the room who were constantly doing the lobbying. And, I think, Leanne, when we, again, I'm just say, having spent some time in that commission and comparing it to what's happening in the Zondo Commission, it's such an example of how commissions should not be run. And we shouldn't forget that Judge Willie Seriti today sits on one of the country's highest benches in Bloemfontein in the Supreme Court. So I think that the importance, again, of this process is it's not just a delving into the past. It's very much about our present. It's about the way in which we conduct similar commissions of inquiry right now in the Nugan Commission or the Zondo Commission. How do we as civil society hold those groups to account? Okay. But the view from the inside, from sitting in the commission, was certainly one that caused great concern. And of course, if I can, as a last point, add, we shouldn't forget that it wasn't only people like myself, but it was people who were employed by the Commission who spoke about a second agenda, about attempts that were made to stop them from investigating issues that they were paid for by the state to investigate. And I think that this case, this challenge by Corruption Watch and the Right to Know campaign really allows us to properly flesh out these issues in front of the courts.
Very, very quickly, David, 30 seconds, we've got to wrap here. This new information that's coming out, is there a chance that Judge Seriti himself could face the law in the event that the court proves that you are right and that the Commission lied to the public and also hid evidence? Well,
let's see what happens. I mean, we are not asking for that. We are not asking the court to substitute a new decision for the Commission's decision. We are simply asking the court to find that the Commission could not have arrived at any credible conclusion given the way in which they conducted the investigation. If the court agrees with us, it would then be up to the appropriate body, the Judicial Services Commission or whatever it was, to decide whether there was further action to be taken.
Okay, all right. From here on, any word as yet? When are you hoping to hear?
Well, our Our opponents have to file their responding affidavit, I understand, within 10 days, so that should be soon. And I hope that we get a court date immediately thereafter, and probably a trial date or a review date sometime in the middle of next year.
David, thank you for talking to us. David Lewis from Corruption Watch, and of course Hennie Van Vuuren, Director of Open Secrets in our Sea Point studios. Thank you both for your time. We take a break. We'll have your news at 7 after this. Stay tuned.